I thought that since we are amending these rules and they take some time, we needed to reflect a lot on some of those issues that we want these rules to cure. And I wanted to bring to your attention something that had taken me to the Rules Committee, and I am mentioned as one of the people who had a deal memoranda, and I had discussed with the chair on how to bring this matter to your attention. The matter concerns the acceptance of people, members to speak, to access, to have your attention in speaking. Because this is a democratic space where majorities and minorities are present. And I had a feeling that I needed to have an amendment to the rules to ensure that all shades of opinion in this parliament be heard on a subject matter under debate, so that it is the speaker ensures purposely. I wanted to get the attention of the speaker. Yes, on Rule 70. That is why I wanted to raise this procedural matter on Rule 70, which we are surpassing. Yet I had recommended a Part C, that subject to Sub-Rule B above, the Speaker shall ensure that the position of all shades of opinion represented in Parliament as are heard on any subject matter under debate. Justification was that Parliament is a democratic space in which the majority and minority coexist and in which all positions need to be heard. That's what I wanted to bring to your attention, Madam Chairperson.
We in Parliament, we cease to look at ourselves as people coming from our respective parties, but we have the people in government and the people in opposition. The proposal of the colleague is that the Speaker would call, can we hear from DP, can we hear from FDC, can we from, that's his proposal. But we thought that once we are here, we would hear from opposition and the ruling party.
Honorable Rule 70, time and manner of speaking. A member desiring to speak shall, in the case of a member physically present in the chamber, raise and face the chair of the speaker, or in the case of a member virtually present in the house, raise his hand or her hands up and shall not speak until he or she catches the eyes of the speaker. Now, honorable members, you want me to start saying, no, we have shades of opinion. Shades of opinion, there is opposition, ruling party, PWDs, military, independent, youth, elderly, women, honor. And if they have not stood up to catch my eye, you get it, eh? Is there any time that we don't pick a person and we remain without nobody talking? There's no time that we don't. Maybe let's hear from the chairman why he didn't make. No, just a minute.
Honorable Chair, we address our mind to the proposal by the Honorable Dr. Lulu. Unfortunately, we couldn't agree with him. There are only two sides reflected, either in the Constitution or in the Administration of Parliamentary Act or even in our rules. That is both sides of the House. No, you see, the thing called independent, we should also, very independent here. I am one, but I'm independent from another independent person. We are not in any lump together, only that we came on individual merit. So the only two sides. So we didn't appreciate the point raised by the Honor. Like, I think these rules sufficiently cover everybody interested, and there is no mischief intended to be cured by that proposal.
Madam Chair,
Right Honourable Chair, it's the proposal of the committee that Rule 73 is amended in sub-rules 2 and 5 by inserting the phrase of chairperson of a committee immediately after the word speaker. Justification. To empower chairperson, Madam Chair, Rule 78 is substituted for the following: interruption of debate. 1. Debate may be interrupted, 1A, by a member of privilege suddenly raising, by a point of order,
By a matter of
privilege suddenly rising, by a point of order being raised, upon a point of information, elucidation, or clarification, and D, upon a point of procedure. When giving leave to interrupt the debate, the Speaker shall follow the following precedent: points of privilege, points of procedure, points of order, points of information, elucidation, or clarification. A member who stands up to interrupt the debate on a point of privilege, procedure, order, information, elucidation, or clarification shall not depart from that point.
And you should also mention the rule.
I'm continuing. Insertion of new rules. The rules.
Let's finish this one first.
No, it is just coming at the end because this one is it all concerns rules.
No, that's a new
78.
rule. That's a new rule.
Okay. It's all concerns Rule 78. So I want to go through first the whole of it. Yeah, but we are particularizing it.
That's 78A.
To appreciate it, you need for me to complete. That's when, because members are going to jump on this without knowing what is amended.
We shall put 2 questions on 78 and then on the new rule.
And there's a reason. You see, if we pass this one and the House has a problem with the subscript, when you've already passed this, what happened?
Okay. You read, then we shall
Because
put
you
2
have
questions.
already passed it. Is that right?
You go through, then we shall put 2 questions.
Yes. Thank you very much, Right Honourable Speaker. Insertion of new rules. The rules are amended by inserting immediately after Rule 78 the following. A matter may arise, that's 78A1, A is capital. A member may raise a point of privilege during debate where a breach of privilege suddenly arises. 2, where a member raises a point of privilege, the Speaker shall make a ruling on the point of privilege. 3, the Speaker shall, in making a ruling under sub-rule 2, have regard to the provisions of the Parliamentary Powers and Privileges Act. 4, notwithstanding sub-rule 2, the Speaker may refer the matter raised on the point of privilege to the Committee on Rules, Privileges and Discipline. 78B, point of order. A member may raise a point of order on unparliamentary language being used by another member or on any matter of unparliamentary conduct by another member immediately the unparliamentary language is used or the unparliamentary conduct arises. 2, where a member rises on a point of order, the member holding the floor shall immediately resume his or her seat. 3, where the point of order has been raised under sub-rule 2, no other member shall, except with the leave of the Speaker, rise until the Speaker has decided on the matter. 4, where a member interrupts debate on a point of order, the member shall cite the rule of procedure he or she deems to have been breached by a member before subjecting the member to the Speaker's ruling. 78C, point of information, elucidation, and clarification. A member may rise on a point of information, elucidation or clarification based on a matter raised by a member holding the floor, and may only proceed with the point if the member holding the floor is unwilling to take the point of information, elucidation or clarification, and resume his or her seat. 2, where a minister is holding the floor and a point of information, elucidation or clarification is raised, the minister shall not reject the point of information, elucidation or clarification more than 3 times. 78D, point of procedure. A member may raise a point of procedure where a breach of rules arises. And members, take a note of this because this is a fundamental departure from the current status. And I repeat, a member may raise on a point of procedure where a breach of rules arises. Where a member raises on a point of procedure, the member holding the floor shall immediately resume his or her seat. Where the point of procedure has been raised under sub-rule 2, no other member shall, except with the leave of the Speaker, rise until the Speaker has decided on the matter. 4, where a member interrupts the debate on a point of procedure, the member shall state the rule of procedure he or she deems to have been breached by the member holding the floor, or on the procedure matter he or she wishes to be ruled upon before the presiding officer makes a ruling. Justification. To clarify when a point of privilege, order, procedure, and information, elucidation, or clarification may be raised. What has been happening, colleagues? Members use point of procedure really to call the presiding officer. They rise up point of procedure and they go in substantive debate when there is nothing procedural at all. So we are now trying to redefine. If you are to sign up on a point of procedure, please be on a point of procedure and state the exact rule. Other than point of procedure and then you go on another tangent. That's what we are seeking to clarify, Madam Chair.
But Madam Speaker, the way I see we running, leadership is politics. And leadership being politics, to be limited and tied not to talk by quoting every rule that every person should say, it is really trying to jeopardize.
I thought that is one of the documents that is given to you when you're being sworn in. So you ought to be knowledgeable of what role you're standing to debate
Right,
upon.
Madam Speaker, but the way the committee is bringing it is really tying our hands so that we don't have freedom of speech in the House.
You know, we need...
You know, in legislation, colleagues, some lacunas are deliberate. It's a principle in legislation. Once you make the law, and this law is too stiff, the chances of breaking that law are very many. That's why they insist on having a malleable law, malleability, malleable, soft, so that the Speaker has a latitude to make a ruling, so that even a member feels free to make a contribution. And I think that's what I think we should be looking at. Let's not make very difficult and stiff regulations that might be misconstrued to gag members' freedom to debate.
Stringent as these rules may appear, the Speaker, the presiding officer, is still at liberty to say you can speak, because she's the custodian of the rules. But these rules are placed there so that we do not abuse the process. But, Right Honourable Speaker, while I agree with the proposals, there is only one that I wish to raise a concern on. 78C2. The proposal in 78C2. It says where a minister is holding the floor and a point of information, elucidation, clarification is raised, the member shall not reject the point of information, elucidation, the minister shall not reject the point of information, elucidation, clarification more than 3 times. Now, that may be okay. My worry is...
Maybe you could put in succession.
Pardon?
In succession.
Yeah,
successive.
Okay, 3 successive times.
Yes.
Yes, but you see, my fear in this, Right Honourable Speaker, even if you put the word successive to correct it, members can deliberately decide that this minister will not speak. Yes, because if I start, Right Honourable Speaker, Right Honourable Speaker, I need your attention on this. Yes. Members can conspire and say, we will not hear him out. When you speak, Naluima says information, Lope says, I'm giving an example, elucidation, and you cannot say, so you sit down. After that, you get back, they will raise it again. Okay? So, Right Honourable Speaker, I want us to be cautious. This rule, it may fail a minister from presenting whatever intends to present.
Honourable
colleagues, these provisions are actually giving us opportunity to interrupt debate. So they are not very stringent. The point that the Attorney General is very worried about is actually to hold Parliament, because the practice of some ministers has been that they will come to read statement, you ask for clarification, one will keep quiet as if he's not hearing, he will read the statement to the end and sit down. There are circumstances where members of Parliament need to be clarified on the information that the minister is giving. So that's why the provision here is saying, yes, you can decline to accept 1, 2, 3, but at least after 3, have sought, and 3 from different members, not the same member Aisha standing and say, information. If you've declined at least 3, give way for people to ask for information and clarification. It's a good thing for Parliament to be informed of what the executive is doing.
We have seen that members abuse all these points of order, procedure. Someone says procedure and they're talking about the goats somewhere. And I think the amendments are curing that. People say point of order and they go on to debate. This is curing that. Right Honourable Speaker, we all swear by these rules when we come here. There's nothing stringent about the amendments. We need to keep our house in order. Sometimes this house looks like a marketplace because people are saying order, procedure, and it has nothing to do with procedure. So, Right Honourable Speaker, I support that we have stringent because you are the custodian of the rules. If you think that I need more time to speak about something, you will allow me or another member to speak. But we can't want to water down the very rules that we swear upon when we come to this Parliament. I thank you, Madam Speaker.
Bring in these rules. And I want to make a clarification on Rule 72.2. Some people are thinking that we are infringing on the immunity, the privileges and immunity of the President. That is not correct under the Constitution. That is not correct. The precondition for the substantive motion is to ensure that there is compliance with the Constitution and any other laws of the land. We only are saying that the President should not be discussed about unless you bring a substantive motion. Honorable Kibal, have you heard? Okay. Yes, Honorable Minister. Honorable Minister, then...
well, first of all, Madam Speaker, I would like to thank you and colleagues, Madam Chair and all colleagues. I want also to try to speak to 78.2. Honorable colleagues, at one time you will be where we are, and at one time we might be where you are. So I want first to say this. When we come here on behalf of government, specifically to address a subject matter which in my considered opinion has been directed by this August House with the rich knowledge of information. There's a reason why I'm bringing this context. Number two, it is also true that sometimes you would like to seek for information, clarification from my presentation. I want to implore us, like the Deputy Attorney General did say, it is also true sometimes you can afford and you can afford to deliberately deny me space to address you. So I want to say this, that the question of information, first I want to go back to the main principle. What's wrong with the current existing rule of procedure which we have been having?
Honorable members.
Because it should be
Honorable members.
at my discretion.
Honorable members, let the minister finish.
It should be at the discretion of a member holding the floor.
Of the speaker.
Of the speaker holding the floor to ask.
No, the speaker.
Okay, the speaker, the chair, and the member holding the floor to give you permission, to give in information, clarification, where applicable. But for us now to begin saying we have 3 times, Honorable Chivumbi is my good friend and many others there. They can afford deliberate to say the subject matter of Ogwang is coming to present on behalf of the Minister of Education, in my considered opinion, should not be listened to, entertained, and you can afford to frustrate it. So, Madam Speaker and Madam Chair, I really want to beg the August House that please, we come here for a purpose on behalf of government to give government business. I want to plead with you, let's maintain the existing rule as it is. I thank you.
The contention was on the issue of the minister 3 times. You get it, eh? On 3 times. A minister on clarification, elucidation, consequent 3 times, the consecutive 3 times, the minister should be able to allow a clarification. Why don't you leave that to discretion of the speaker? Yes, leave that to the discretion of the speaker. Why are you, honorable members, why are you over-reducing the powers of the speaker?
Right, Honorable Chair. Right, Honorable Chair. The current situation, can I be heard? It is the discretion of the minister holding floor. And what they have done, they have consistent, some, not all of them.
In most cases, you've seen the speaker saying, clarify, take the information. In most cases. Yes. Yes. I remove that part. Reframe.
Right Honorable, we are proposing to say this proviso notwithstanding, okay, the minister shall, okay, I may not word it properly, but the minister shall be required to yield once.
But you people, is there somebody chairing this house? Is there somebody chairing this house?
Yes.
The speaker is chairing this house.
Yes.
Yes.
So, Chair.
Even if somebody rose up on a point of information, it is a speaker to allow. So why are you pushing the whole burden to the minister? Daudi, you wanted to say something? Honorable Minister.
I wanted to move in unison so that we avoid an orchestrated or deliberate effort to frustrate a minister. What if the 3 times is repeated? Should we now rest in the solace of the speaker intervening? Or we need some express provision, a proviso of sorts to say, provided the repeated interruptions don't go beyond a certain point, maybe something like that.
us get away from reliance of the presiding officer's mood. Sometimes the presiding officer's mood could be that the person should not give way. I pray, Chair, and I beg your indulgence that you don't misunderstand me. I pray that you allow us have a role that will protect members from reliance on the Speaker's mood, so that we have a role for the ministers to give way, to give us information, because
Honorable
the information is
Aisha,
necessary.
Honorable Aisha, the Speaker's role here is to protect all members and ensure that there is harmony and orderly in the House. Yes, and when we are doing that, we are doing it for the good of Ugandans out there. This, yes.
Right? Including our own rules. It's because there is a mischief we are intending to cure.
What are we curing now?
Now here, in cases where a minister has refused to yield, the Speaker has already said, please yield. So what is the mischief that we are trying to cure?
Can I answer that? Madam Chair, it's not about him as an individual. So when a member is seeking clarification, the Speaker doesn't know what clarification. It's the member who knows the clarification.
Who gives the member permission to speak?
The presiding officer does, but not until you have put the clarification. You only stand up and say clarification. And that's the only judgment you have to use. But the substance of the clarification is the member raising it, who knows? So if you just stop him without you as a presiding officer even knowing, that's what they put you in a difficult position. Because, Right Honourable Speaker, let me make my point. Right Honourable Speaker, this has nothing to do with the presiding officer's powers. Why? When a member stands up on a point of clarification, he does not go ahead until the Speaker has given him the audience. You will not hear the clarification, you as a minister, until it has been put on the floor. But if you consistently say, no, no, and somebody is seeking clarification, because they are not asking about the Honourable Kafus, they are talking about clarification from the Attorney General.
See anything, we are curing. In the circumstance that a rule is not provided for, we shall apply Rule 8. So can we have that part of
whatever we're discussing about, anything touching the powers of the Speaker should be disregarded. Yes. Madam Chair?
Yes, I'm listening.
Any discussion regarding the powers of the Speaker should be disregarded, because the Speaker must maintain the power he or she holds. No. I'm being honest. Because we shall not cure.
I have not given you to talk. Chair, I have not given you to talk. Sit, Hassan.
Madam Chair, the fact that the front bench is worried about the insertion of that particular rule is problematic in itself. Points of clarification and elucidations rise because members want the minister to clarify on that particular matter. Now, deleting it and shying away from it means that we are leaving the members out of debate that is happening at that particular time in the House. Madam Chair, we know we legislate for our people, and rules are rules. We have to respect rules, else we are savages. So my application on that rule, Madam Chair, is to allow the chair proceed with the rule the way it is, because it's going to allow the members to come in that particular debate. Thank you, Madam Chair.
Ever since we started amending rules, we've been amending them in good faith. But when you look at this sub-rule, the ministers are saying, no, let's remove it. The other side are saying, let it remain. Why don't we delete this so that we keep what we have been using as Parliament? Because we have to amend these rules in good faith so that we maintain the good faith. Thank you.
Yes, Itungo, then Moses.
Chair, Madam Chair, the chair is in the meeting, but okay, I want to bring to your attention Rule 70, which you have just read, and specifically the last paragraph. The last paragraph we are saying that a member shall not speak until he or she catches the speaker's eye. Now, if the rule is already there, why do you want a person to raise a point of information or procedure without the eye of the speaker? So,
no. But where the problem arises is the 3 times. My question now, 3 times by who? By an individual member who is standing to ask for clarification, or for members? All the 3 members.
3 times. 3 times, yes.
Seek clarification again, maybe from the Attorney General or the Chair, because what if members conspire, like 10 of them or 20, from either side, the opposition or NRM side, and they are deliberately doing that to fail a minister? Because the rules here dictate that maybe, unless the speaker is not allowed, but after the minister's presentation, members will debate. What if something that you have not, the minister has not brought out well, you note it down and you bring it out in the debate? Without because many members are going to conspire here, order 20 of them, and you fail the minister. Can't we do that in a debate?
Thank you.
Madam Chair.
Thank you. I was trying to say that we are trying to deal with 2 principal issues here. 1, access to the microphone and the power of legislation. 2, the doctrine of separation of powers. This is a space for members to legislate and represent their constituencies. And for the ministers, it's space for accountability. And therefore, the amendment, if I understood the chairperson well and the committee's intentions, is try and cement the power of members to demand for accountability from ministers, and therefore there should be no denial. We have been here, and ministers are denying clarification, and then they take leave and even take flight. Chair. And when that happens, you constrain the whole intention of legislation and representation. The speaker, under the rules, will be at latitude to even say, I have ordered that this matter takes leave. That power cannot be taken out from the speaker by this rule. That's why I took exception to the submission of the Olabongo Peck, who was trying to incite you, as if this rule has eyes.
Nobody has incited me.
Of course, I saw him as the speaker, but of course you were smart to.
Nobody has incited me, but I'm also telling you, much as even if you stand 10 times, but if the speaker has not given you time to speak, you speak.
Exactly, that's why.
But at the same time, if somebody is standing up on a point on clarification, I have seen so many times ministers not wanting clarification, but the presiding officer says, clarify, take it, give using that.
So chair is because the presiding officer does that discretionally because doesn't know the matter of clarification from the member at the time the member rises.
We've never asked for what clarification. All we want is let the member seek for a clarification.
That's my point, right, Honorable Speaker,
Okay,
and I think they
okay.
are getting away with not accounting for the actions.
Okay.
Question only once, and you have allowed a member to ask the minister, and ministers have given way. Of course, we also have ministers who fear to respond to questions from members. But with your discretionary powers, we have seen situations where you have allowed members here to raise their matters to the ministers. Just like point of procedure, just like order, it is at the discretion of the Speaker. So my humble view is that the way it is, and members also, the ministers, should be able to give way. Why do you fear to respond to our clarifications? Thank you very much.
The many different views we have on this. And for avoidance of clogging the system going forward, I move that the proposed amendment under Rule 78C2 be deleted.
Chair.
Chair, I'm going to respond to the request of the Attorney General. But before I do that, I have to say this. Sometimes the reason why people have been jumping, or colleagues have been raising point of procedure, whereas they are not point of procedure, or even order when it is not, is because they are afraid to get a clarification. So they move, they move around and they say procedure. Moreover, it is not procedure at all. But having said that, I hope the executive has picked the lesson that members want the clarification. And if you continue behaving the way you are, we shall bring the amendment again. As of now, for peace, let us consider that particularly. But if you do continue behaving like it has been, we shall be back with that amendment. I concede right or not.
Thank you. Honorable Member, that Rule 78, with its attendant amendments, as proposed by the committee and modified by Doug, be approved by this honorable House. Those in favor say on the contrary, nay. Let's have it.